Right, these are your Unit 1 forensics notes. The first unit is kind of just introduction to forensic science. We will be talking about the different types of laws, as well as how to classify and collect evidence. So forensic science is also called criminalistics, and it is the study and application of science to matters of the law. Application of forensics comes from many different areas, including anatomy. That would be things like fingerprints, hair, bones, teeth. Mathematics, there's a lot of mathematics when it comes to different ratios, formulas, graphing, distance. Language arts, they need great communication skills to be able to communicate with lawyers, prosecutors, things like that. Social studies, obviously, because there's a lot of laws involved. There's different psychology involved. We'll talk about psychology a little bit later this year. Chemistry, so that comes into play with different mixtures when we talk about toxicology analysis, analysis of arson crime scenes. Physical science, that would be things like paper and ink analysis, handwriting, typewriting, forgery. Also includes earth science with soil evidence, things like casts and molds. Technology, especially with the rise of like digital crimes. So computers, chromatography, spectrometry, microscopes, electrophoresis, all of that kind of falls under that technology umbrella. Physics in terms of blood spatter, determining trajectory, speed, velocity of blood, as well as bullets and other ballistics. Biology, including DNA, genetics, entomology, which is insects, botany, which is plants, and zoology, which is animals. So what exactly does a forensic scientist do? Their job description is that they are responsible for processing and documenting crime scenes. They are responsible for collecting and preserving evidence, analyzing and comparing evidence in a laboratory, reconstruction of the data from sort of the best theory of events in the case. So they're basically going to look at all the evidence, come up with a reconstruction of what they believe happened. And then a lot of times, if there's a lot of forensic evidence, they may be called to provide what we call expert testimony in a court case. In order to be a good forensic scientist, you need to have good observation skills. You have to be able to find evidence that other people may overlook. Good analytical skills, being able to identify a problem, organize the information, draw conclusions based on the evidence, and good deductive reasoning. So deductive reasoning is using logical steps in order to draw a conclusion based on facts or evidence. The couple like crime scene puzzles that we've done in class are examples of what deductive reasoning is. It's using clues and evidence to ultimately come to a conclusion. So deductive reasoning is a little different than what you may do in other science classes. In deductive reasoning, you kind of have an idea of what happened, like, is it a suicide or is it a murder? Then you're going to look at the observations, look at the evidence. Does it support that? Yes or no? And then you're ultimately going to come to your conclusion, right? It's a little bit opposite than what we do in other science courses, where we make observations first, then analyze that in order to come up with our theory. Deductive reasoning operates the opposite direction. All right, so there are different types of criminal cases, and different types of cases are going to receive different types of forensics treatment. So forensics are used more against crimes against persons rather than crimes against property. So crimes against persons would be things like assault, battery, rape, murder. Forensics is used more in those types of cases than it is with property cases, such as property cases like vandalism, for example, right? Or trespassing. Different types of physical evidence analysis is going to obviously go with different types of cases. For example, a drug possession case is going to involve more toxicology with identifying the types of drugs and amounts and things like that. We mentioned before, DNA evidence isn't going to be in every single case. It's only going to be in cases where it's absolutely necessary. So just keep in mind, not every type of evidence is at every single kind of case. And certain types of physical evidence are associated with particular crimes. For example, burglary is associated with tool mark evidence. Tool mark evidence would be like the remnants left behind from using like a crowbar, for example, to pry open a door or a window. That's the type of evidence you wouldn't necessarily see with a crime like, I don't know, rape, for example. All right, there are different types of laws in the U.S. criminal justice system. First type of law is called statutory law. This is known as kind of the law on the books, so to speak. These are legislative acts that are passed by Congress that declare, command, or prohibit something. They've been enacted by a government body or agency such as Congress and are based on the Constitution. So they use the Constitution to kind of guide their thought process, but then they pass specific laws for like specific types of crimes and situations based on what the Constitution is telling them to do. So this can be either at the state level or at the federal level. Common law or case law are laws that are made up of judicial opinions and precedents set in appellate courts. A good example of this would be Roe versus Wade or Brown versus Board of Education. Those were kind of big, important judicial decisions that ultimately shaped the laws in the country. So Brown versus Board of Education was desegregating schools. So that precedence, that judicial decision ultimately led to that law. Roe versus Wade is a similar one, but with abortion. So they kind of use that court case in order to justify their reasoning for other cases that fall under the same category. Civil law is often referred to as private law. This deals with relationships between individuals. So this includes things like property matters, contracts, marriages, divorces, wills, negligence, and other sort of civil concerns. Violations of civil law are usually just fines or transfer of property. Civil law usually doesn't involve things like jail time or probation, things like that. Most of the time it's fines, although obviously in extreme cases of negligence, it can be prison time. And then criminal law is what we're going to focus on most of the time in forensics. Criminal law is often referred to as public law. This deals with regulation and enforcement of people's rights. These are offenses against an individual and are usually offensive to society. So these are things that society as a whole has deemed as being, like improper, things that are, against the common good of the society. For criminal law cases, the state is going to be the plaintiff in the court. For example, if it's Jones versus Michigan, Jones would be the person that committed the crime, and Michigan would be the state that is charging them with the crime. So it's not going to be like Jones versus Smith. It's never the suspect versus the victim. It's always going to be the suspect versus the state, or sometimes even the U.S., depending on what type of crime it is. So under criminal law, we have misdemeanors. Misdemeanors are minor crimes such as theft, minor assault and battery, or possession of small amounts of drugs. Felonies are major crimes such as murder, rape, armed robbery, serious assault, dealing illegal drugs, fraud, auto theft, forgery. Those all fall under felonies. In criminal cases, the prosecution is responsible for proving guilt beyond a reasonable doubt. So they need that in order to convict the suspect. It is the job of the plaintiff, so the state, it's the job of the state or the nation, in order to prove that they have enough evidence that this person did it. It is not, for example, Jones is not responsible for presenting evidence to show he's innocent. It is the state of Michigan's responsibility to show evidence that he is guilty. Violations of criminal law are punishable by fines, or community service. It could be probation, incarceration, either in prison or jail. It could be things like life in prison, or even capital punishment, which is the death penalty. Still available in some states. There's no rule federally for the death penalty. There is also equity law. Equity law is remedial or preventative. So these are measures that people take just to protect themselves. Includes things like injunctions and restraining orders. Administrative law are laws established by different agencies in the U.S., such as the IRS, obviously determines the tax laws. Social Security and other branches of the military also fall under administrative laws. Each of those agencies has the power to create their own laws for whatever their jurisdiction is. All right, all collectors and handlers of evidence must be aware of the rights guaranteed in the Bill of Rights by the U.S. Constitution. Bill of Rights is the first 10 amendments. Those protect individual rights. We have to make sure that they are not violated. And some of those rights include protection from unreasonable search and seizure. So people that collect evidence have to make sure that they're not breaking that. Everyone has the right not to be arrested without probable cause, the right to be presumed innocent until proven guilty, the right against self-incrimination. So self-incrimination would be they are not forced to confess, essentially. Also includes things like they're allowed to have a lawyer kind of guide them through that process. The right to a fair and speedy jury trial that will be free from cruel and unusual punishments and excessive bail and fines. All right, so the goal of an investigation. The goal of a crime scene investigation is to recognize, document, and collect evidence at the scene of a crime. Solving the crime will depend on piecing together the evidence to form a picture of what happened at the crime scene. The evidence collection is based on something called the Locard exchange. The Locard exchange, basically, a Locard exchange principle says whenever two objects come in contact with one another, a cross transfer of physical evidence can occur. The intensity, duration, and nature of the materials in contact determine the extent of the transfer. So that basically means when a criminal is in a place, there will be some sort of transfer of evidence that happens. In terms of intensity and duration, intensity would be like if two people are in a physical altercation, there's going to be more evidence left behind than if it is something that is very sneaky and passive. The duration would be like how long did that fight occur? Was it one blow to the head, or was it, a prolonged fight? Longer fight is obviously going to leave behind more evidence. And then the nature of the materials in contact. So if there was blood, or if there was hair, if the criminal was wearing gloves, if they were wearing a hat, all of those kinds of things are going to affect how much evidence is transferred to the crime scene. So there are a couple of different types of evidence. There are two categories that every piece of evidence can be classified into. So there is direct evidence. Direct evidence only includes firsthand observations. So these are things like eyewitness accounts, videos, and confessions. So if for a particular crime there is someone who has personally witnessed the crime happening, that's direct evidence. If there is video recording of the crime happening, or the person has confessed to the crime happening, that is direct evidence. There is beyond a doubt, hopefully, that it happened in the way that the person is describing, right? That's considered like the best type of evidence. The other type of evidence is called circumstantial evidence. Circumstantial evidence is indirect evidence that's used to imply a fact, but doesn't actually prove it. For example, if there is blood found at a crime scene, we can't prove that it came from that particular crime, right? We can prove that a person was in that location, but we can't prove that because they were in that location that they actually committed the crime, right? For example, or someone's fingerprints could be on a doorknob. That doesn't mean that they used that doorknob to enter the crime scene. It could have meant they were there the day before, or an hour before, or an hour after, right? We just know that they were in the area. It doesn't prove they did anything. It just implies that they were there at some point. So another example, finding a suspect's gun at a crime scene is circumstantial. That just shows that the suspect was there. It doesn't mean that the suspect shot the gun or shot a particular person. Just means the suspect was in the area. You need a lot more circumstantial evidence in order to build your case than you do with direct evidence. So when we talk about circumstantial evidence, that's really what we're going to focus on in class, are the types of circumstantial evidence. We can categorize that into a couple different categories as well. So physical evidence, these are things that are not living, not organic materials. So physical evidence would be things like synthetic fibers, weapons, bullets, shell casings, paint chips, documents, imprints, and prints, meaning like shoes or tires, like left in the mud, for example. Any tool marks, soil, drugs, all of that is considered physical evidence. If it's not physical evidence, then we would categorize it as biological evidence. Biological evidence is evidence that comes from a living thing, right? These would be things like a body or body parts, any sort of body fluids. Hair, if it has the root in it especially, is biological evidence. Leaves or other plant parts would be biological. Natural fibers like cotton, feathers, wood, all of that is biological evidence. And both physical and biological evidence, if it is in very small amounts, we call it trace evidence. That is small but measurable amounts of physical or biological material found at a crime scene. For example, if we find a single strand of hair, or we find a small sample of DNA, a single drop of blood, pollen, gunshot residue, All of that would be considered trace evidence because it's in very small quantities. It's usually stuff that we have to look very, very carefully for. And then we could categorize each of those as physical or biological. For example, DNA would be biological trace evidence, while gunshot residue would be physical trace evidence. For circumstantial evidence, you need more circumstantial evidence. The more circumstantial evidence you have, the greater the weight it carries, right? So if you have 10 pieces of circumstantial evidence aligning with one particular suspect, it is more likely that that person committed the crime than a different suspect that only aligns with 2 pieces of circumstantial evidence, right? So when we have the circumstantial evidence, we need much more of it to prove that someone was there. If it's direct evidence, like we talked about, like a video recording of it, that's pretty convincing just with one piece. But with circumstantial evidence, we're really looking for multiple pieces of evidence. All right, we can further classify circumstantial evidence. These are the 2 groups we're going to focus the most on. This is what students have sometimes a difficult time distinguishing between. The first classification is class evidence. Class evidence is going to narrow the evidence down to a particular group of people or things. This type of evidence is not going to tell you which exact person. It's just going to narrow down your group of suspects. For example, blood type. You could have blood type A, B, AB, or O. If you find blood at a crime scene, it's very cheap to test for blood type, so we can do that very easily. Finding a particular blood type at a crime scene narrows down your suspects, but doesn't tell you which suspect it is, right? If you're looking at 10 different suspects and the blood at the crime scene is type A, and only 2 of your suspects are type A, then you can eliminate those other suspects and just focus on those other 2. So it didn't tell you which one exactly, but you know it matches one of those 2. Okay, that's class evidence. It just narrows down that group. That's different than individual evidence. Individual evidence is going to narrow it down to a single person or a single item. For example, fingerprints. If we find fingerprints somewhere, we can analyze the fingerprints and match it to one specific person. Same with handwriting, same with DNA. When we find a DNA sample and test it, it matches one specific person, right? Class evidence narrows down a large group to a more narrow group. Individual evidence pinpoints one specific person. Right, once we find the evidence, we must secure it and collect it properly in order for it to be allowed in the courtroom. Anything that is bloodstained must be packaged in wrapping paper, manila envelopes, or paper bags to prevent the growth of mold, which can destroy the blood evidence. For blood, air must be able to flow around the evidence to prevent that moisture from building up. For biological evidence, especially blood, we want it to be able to dry. If it's left in a plastic bag where it can mold, that's going to destroy whatever testing we could possibly do on it. So anything that's bloodstained, we want to store in paper to allow it to dry out. That way, in the future, if we want to test it, we can rehydrate it and the sample would still be valid. If we're doing an arson investigation, an arson would be like purposefully burning something. Charred debris from that fire must be sealed in an airtight container, such as a new metal paint can, in order to prevent any volatile petroleum residues from evaporating. This could be evidence of arson. So if they suspect arson, they're going to put the charred remains in a container and seal it. Because if anything like gasoline, kerosene, propane, any of that was used to purposefully light the fire, those are things that evaporate very quickly. Putting it in an airtight container is going to keep those volatile substances contained so that they can be tested for later on. So anytime we have biological material, we want to package it in a dry paper bag to prevent any mold. That's going to preserve the DNA if we need to go back later and test it for DNA evidence. That's been happening with some cold cases lately. They tested samples, could be like from the 70s. They have evidence that we want to currently test for DNA, 50 years later. And we can if it is properly packaged and dried out. And so there's no extra moisture or mold in it. If there is trace evidence, remember that's small pieces of evidence like hairs, fibers, tiny shards of glass, small amounts of soil. We're going to use small envelopes or tins to collect that evidence, we're not going to use plastic because plastic tends to have a lot of static on it. And we don't want that static to interfere with the hair or fibers or soil or whatever's in there. Trace evidence should not be removed from garments, weapons, or other small articles. If we find trace evidence on an object, we're going to collect the entire object and send it to the lab. For example, if we find a shoe that has a small sample of soil on it, instead of collecting that soil, we're going to take the entire shoe as evidence and package it appropriately. Fingerprints. Fingerprints are lifted and attached to an index card. So there's a picture of that over here. So there will be like cards of paper with the fingerprints that were collected at the scene. Like we said, any arson debris is going to be packaged in sealed paint cans or mason jars, something that's airtight. And casting. So castings would be like if there are tire tracks in the mud. If there are tire tracks in the mud, then we are going to package it in a box that has cushioning in it to prevent that cast from breaking. So that's what they're doing up here, right? They found a footprint. They put plaster in it to get an impression of what that footprint was like. Once that dries, they're going to lift that casting and put it in a box with cushioning so it doesn't shatter. Something really important when it comes to evidence is something called an evidence log and chain of custody. An example of it is on the right-hand side. The evidence log and chain of custody must be attached to the evidence container, not just one evidence container per crime scene. A piece. We need this document for every single piece of evidence collected. So on the evidence log, you can see up here, it includes a description of the evidence, the name of the suspect, the name of the victim, the date and time that they collected the evidence, signature of the person that collected the evidence, and signature of any witnesses that were present while that evidence was being collected. That would be all included in the evidence log, this top portion. The chain of custody, you can see, is at the bottom. This is a list of every person who came into possession of that item of evidence. So you can see this first line says received from, by, date, and time. So they received this from this person on this date at this time. And we can track where that piece of evidence goes, right? Once it's collected, it could come in contact with a bunch of different people, right? It may go from the first forensics officer, then to the forensics lab. Then it may go to a different forensics lab. Then it may eventually go to the district attorney. Every single person's name must be on that chain of custody. You must be able to backlog and see who had possession of that piece of evidence and when, so that if something were to happen to that evidence, if something is altered with it, we can trace back to who could have possibly done that. If the chain of custody is ever broken, meaning if someone does not write down when they received it and who they received it from, then that evidence will not be allowed in court. So it's super important that chain of custody is followed. Otherwise, you may have a really strong piece of evidence that could, prove without a doubt that this person committed a crime. But if chain of custody is broken, then that cannot be used in the courtroom. A judge will not allow it. Each person who comes in contact with a piece of evidence must use proper procedure and protocol in order to maintain responsible handling of evidence from the crime scene to the courtroom in order for the evidence to be admissible in court. If anything is questioned along the way, the judge is likely to throw out that piece of evidence, and then the prosecution has to rely just on the other evidence that they have. All right, that's the end of your notes for Unit 1. Please make sure you submit it on Canvas, and we will review them together in class.